You may proceed.
May it please the Court, my name is Patrick Frank. I'm here on behalf of the appellant, Wayne C. Clemmer, in this case. At the inception, I'd like to reserve 5 minutes by way of rebuttal. This case extends from a claim in the trial court based on age discrimination. Wayne Clemmer was a hotline operator for the Department of Children and Families complaint hotline. He brought a claim for age discrimination pursuant to the Florida Civil Rights Act, 1992, Florida Statute 760. In the fall of 2009, this case was set to go to trial. We had a summary judgment motion. A summary judgment was entered by the trial court, predicated on several bases. They were as follows. Prior to the summary judgment motion, there was a U.S. Supreme Court decision in a case called Gross v. FBL Financial Services, and it dealt with the U.S. Supreme Court's interpretation of the Age Discrimination in Employment Act. Although the appellant vigorously opposed the application of the U.S. Supreme Court's interpretation of the ADEA in the Gross case.
The language is the same.
Pardon? The
language in the two acts are the same.
The language in the two acts are similar, Your Honor, but we do believe.
Aren't they the same? You have to show that the age discrimination was the cause of the discharge or adverse employment decision?
Well, what you're respectfully, Your Honor, what you're speaking to, I think, is the court's interpretation as to what the evidentiary standard is for bringing a claim.
No, this is not an evidentiary standard. This is a substantive standard.
You're correct. The language of the Florida Civil Rights Statute mirrors, with respect to.
That's all I asked. With
respect to the age discrimination and companion claims for other types of minority discrimination, is the same. It has to be based on the membership in a particular minority group or protected class. Our contention is that Gross should not apply for. Well, first of all, the implications of Gross are, we believe, are chilling with respect to employment law in the state of Florida. We believe that applying the Gross standard to the Florida Civil Rights Act basically completely eradicates age discrimination claims in the state of Florida, because under.
Well, but I don't understand how we would not apply it.
You wouldn't.
Under what principle would we not apply Gross?
You wouldn't apply Gross, Your Honor, for several reasons. One of which being is, and as we noted in the brief, this is a step. The ADEA under Kimmel v. Board of Regents, first and foremost, is a statute under which the particular appellee in this case would be immune anyway. So basically, political subdivisions of the state or state actors are immune under the ADEA.
That has nothing to do with the issue. That has nothing to do with the issue of whether the language as to causation applies, which is identical.
I think what the court has to. This is a situation where the U.S. Supreme Court relied on the strict statutory language of the ADEA to come to a decision, and because of that. Specifically because of that, I think it's very important that every distinction between the FCRA and the ADEA has.
What is the distinction in question that you're relying on?
The distinction in question, Your Honor, is the principle that, on the principles of the Constitution, federalism, the state of Florida has the right to create.
You definitely have the right to do so. The reason, the question is, why should we?
Because we believe that the way that the.
You just think the result is wrong.
No, Your Honor. I believe that.
You think it's wrong.
I do think that the result is wrong. Yes.
Okay.
But if I may, Your Honor, I believe that the result is wrong for a variety of reasons. One of which is the fact that we believe that the Florida Civil Rights Act was intended to abide by this principle that the states are free to create civil rights or confer civil rights that provide greater protection than the ADEA.
There is no doubt about that. The question is whether the state did it by enacting the same language that the Supreme Court interpreted of the United States in the Grow case.
We do believe that.
I know you believe that, but for what reason?
The reason why we believe that, Your Honor, is simply in the construction of the statute. When you look at the various patchwork of federal statutes, the ADA, the Rehabilitation Act, each is a completely separate statutory regime under federal law. Under Florida law, what we've done is we've taken every single suspect group, every single minority class, and we put them all together in one statute. We haven't separated them out and said, and the effect of treating these cases differently is we've basically ironically, we've created a situation where we have subdivisions, or we have more protected classes within the Florida Civil Rights Act than they're no longer.
Counsel, you need to win on every single one of your points in order to get a reversal in this case, don't you? You not only have this majestic constitutional or legislative problems, you've got a lot of problems with the facts here.
Okay. Well, Your Honor, and that's a good point. The other issues that are before the court with respect to the bases upon which the summary judgment was based, the first one being following the application of the Gross decision, the second one being that the issue of the similarly situated personnel. The trial court determined that for the purposes of summary judgment motion that the appellant wasn't similarly situated from the proffered comparators. We believe that was a misapplication.
Doesn't the first line say that the plaintiff and the comparator have to have the same supervisor?
It does, Your Honor, but
they didn't have the same supervisor.
If I may, Your Honor, what first line are you referring to?
The first line of the pertinent question, the pertinent definition of a comparator.
Actually, respectfully, Your Honor, I disagree with that because there's case law out there, and that we've provided in the brief, that says that it doesn't necessarily have to be the same supervisor. There can other courts have.
Well, if it's a group decision, but this wasn't a group decision.
Well, we actually dispute that, Your Honor, but what I'm saying is that there are other court decisions out there that have changed, that have looked to other criteria other than the supervisor.
Under certain circumstances, which such circumstances don't apply in this case.
We believe that they.
You believe every single point has to be resolved in your favor.
Okay,
right?
Your Honor. Well.
You know, aside from all of that, these cases are based on age discrimination. The only thing in this case that supports that is the fact that your client was 68 years old. There is nothing in this record, it seems to me, that indicates that this decision was made on any basis other than the contents of his phone conversations. Plus, I might add, the nature of his deposition. This fellow doesn't seem to be cut out for this job.
Well,
In fact, didn't he even list several reasons why he might have been fired? I mean, didn't he list that he had called his supervisor honey, and hadn't he listed, I don't know, a letter to the governor, and he listed several things as to why he might be fired, several reasons as to why he might be fired.
What is there in the record which has any semblance of indication that this man was fired because he was 68 years old?
Well, Your Honor, if I may.
You distinguish a lot of everything else,
okay,
but you have nothing positive.
Well, there's testimony in the record from several other colleagues of Mr. Clemmer stating that they had observed anecdotally and empirically issues in which they felt that they were being, Mr. Clemmer and other people over 40 were being singled out and treated differently from the younger employees. But Your Honor, it's significant to note that the trial court never even got there. We didn't get to that point.
This is a summary judgment that be affirmed if the record supports it on any basis.
I understand, Your Honor, but the issue is that the trial court hung its proverbial hat on the issue of the application of gross, the similarly situated analysis, the same decision-maker scenario and the pretext.
And you just want them to go on 5, 6, 7, and 8, right?
No, Your Honor. Those were the issues that were. We disagree that pretext was discussed. I mean, basically, at the end, at the summary judgment, once we learned that gross was going to be applied, we knew that, given the fact that Mr. Clemmer had acknowledged that there may have been a mixed motive scenario, then it would have been an uphill battle at that point in time to survive a motion for summary judgment. But we believe that gross was misapplied in the context of this case.
Of course, in a proper rules of appellate decision-making, you don't go to the big issue if you can resolve the case on the little issues, such as the insufficiency of the evidence to support this claim. We don't have to get into what, in a proper case, the gross standard should be, although I have a lot of doubts about your correctness even on that issue.
Well, Your Honor, respectfully, we do believe the record does support with circumstantial evidence an age discrimination claim, but we'll reserve 4 minutes for rebuttal. Thank you.
Good morning, Your Honors. My name is Miriam Coles, and I'm here for the Department of Children and Families. Ultimately, I think we're here today because of a few undisputed facts. It's undisputed that Wayne Clemmer, while working in the Hotline Call Service Center, where he's taking calls from citizens reporting the abuse, neglect, and exploitation of children, he's working in this capacity. He's been counseled several times for poor performance. He was recently sent to remedial customer service training because of inappropriate comments he made to other callers. And he says to the father of a child who's reporting suspected abuse, "She's 5 years old, man, 5 years old. What's she got to touch?" And he laughs. He admits that this occurs. The father calls and complains twice to the hotline. And these are the factors that decision-maker Susan Henley considered, not age, when she made the decision to terminate his employment with the hotline. As Mr. Frank has articulated, the circuit judge did grant summary judgment for the defense on the 3 grounds that he's asserted. And as this court has already articulated, if we prevail on any 3 of those grounds, they are independent and the summary judgment should be affirmed. First, I think one of the first issue that the court ruled was the same supervisor standard. And I think the law is clear that in order for 2 comparators to be considered similarly situated, they have to have the same ultimate decision maker. Mr. Frank is correct that there are cases that say different supervisors is not always determinative, but that's because the decision maker is who is at issue. In the cases that they've cited, EEOC versus Stock, the Wren versus University of Central Florida, and the Rue versus City of Atlanta, in all those cases, the court either held that the standard is the same supervisor, or the rationale behind the ruling that they were similarly situated is that they had the same ultimate decision maker. I think the purpose of the burden shifting analysis, where you have to have discriminatory intent, and whose intent is it that we are inferring by this similarly situated analysis? It's the decision maker. It's the person who's making the adverse action against the employee. Mr. Frank has also raised the issue of cat's paw. He wants to assert that Ms. Henley was not the one who made the ultimate decision, but she just rubber-stamped a biased recommendation. And it's true that you can get around the same supervisor standard if you can show this, you can show that the ultimate decision maker was a mere conduit of discriminatory animus of another. However, there's no evidence of that in this record. It's clear from the record that Ms. Henley conducted her own independent evaluation, which is what the law requires, in order for that mere conduit not to have occurred.
And he referred to a deposition on that point. I forgot the name of the person to whom who was deposed, but then you argue that it wasn't in the record here.
Right. He refers to the deposition of, I believe it was Ms. Cassandra Floyd. That's not in the record on appeal. And in the circuit court addressed that testimony, the circuit judge.
Well, that's what I was going to ask you. You say that deposition wasn't presented here as part of the appellate record. Was it presented to the trial judge.
It was presented to the trial judge.
Well, if there's something in there that supports
nothing.
his point of view, then I suppose we have to give him an opportunity to supplement the record. But that's why I wanted to ask you, what is in that? What is it?
Your Honor, that testimony was there is a manager, a mid-level manager named Paul Berryman who works at the hotline, and the testimony was that Ms. Floyd was in a meeting where Mr. Berryman was trying to get Ms. Bonnie Chapman to sign a resignation letter. He was explaining to her what would happen if they fired her versus what would happen if she resigned. And our position and the circuit court's ultimate ruling was there was nothing in that testimony that said he was the one who made the decision. The fact that he was the bearer of that bad news does not mean that he was the one who made the ultimate decision. And that was the extent of that.
Well, and I don't mean to suggest that we would be required to order supplementation of the record. Perhaps the appellant would lose on another point. It would be unnecessary. Are there independent points for affirmance here besides this cat's paw theory?
Yes, Your Honor. Second, contrary to what Mr. Frank has represented, the court did address the issue of pretext and found that there was absolutely no evidence in the record of discriminatory intent, which is what you have. Pretext requires that the plaintiff show not only that the proffered legitimate business reason was false, but that the real reason was discrimination based on age. And there is no evidence of that in the record. There are no similarly situated comparators. There is no the plaintiff himself admits in his deposition that no one ever made any ageist comments against him. They have referred to some of this Me Too evidence.
He blamed Governor Bush, and he's not even the governor anymore.
Well, and there's no evidence that there was a conspiracy by Governor Jeb Bush to discriminate against Mr. Clemmer based on his age. With regard to the Me Too evidence that they try to offer, Sally Holt, Bonnie Chapman, some of these other people who were disgruntled and brought claims, only 2 of them actually brought age claims. The others had maybe race, and there was some disability discrimination. But the important thing is in all of their testimonies, they all say they base it on what they saw at the hotline. We saw younger people. But they admit that they don't know the ages of any of the hirees, and they don't know the ages of any of the applicants. So their conclusory allegations about the ages and treatment of older employees is not grounded on any evidence. It's inadmissible hearsay. So that can't be used to support the pretext argument. And finally, I think we have the gross opinion. I think it's clear that the Florida Civil Rights Act is interpreted according to federal statute that's laid out in almost all the Florida cases, Sondel, Bryant. In this case, the gross standard would apply, and it requires a but-for causation standard where he has to show that the reason that he was discriminated or the reason he was terminated was because of his age. In this case, he cannot establish that. He admits to the misconduct. He admits that the department had the right to discipline him. He just disagrees with the level of the discipline, and that's insufficient basis for a claim, as has been stated by federal courts in the Chapman versus AI transport case. Also, as you pointed out, Your Honor, he comes up with other reasons for the termination, such as the fact that Jeb Bush was angry at him for writing a letter and was just looking for any opportunity to get rid of him. He called Susan Henley honey in a meeting, and then she wanted to get rid of him to show him who was boss. Also, his purported idea that the reason they were getting rid of old people was to get rid of the higher-paying employees. That's not even actionable under the ADA or the Florida Civil Rights Act. So under the gross standard, which does apply in this case, he can't meet that. So we prevailed on all 3 of those. With regard to his argument that the Florida Civil Rights is different textually from the ADA, in gross, the Supreme Court is interpreting just one small phrase, the because of phrase that appears in Title VII and the ADA. It's identical to the phrase that appears in the Florida Civil Rights Act. The court notes that the ADA was not amended in 1991 to add the mixed motive method of proving an unlawful practice. Similarly, the Florida Civil Rights Act has not been amended to allow a mixed motive analysis. So gross should apply, at least in the context of age cases. Any other, he's raised some interesting issues about the causation.
You've already given us 14 reasons for affirmance. Do you wish to continue?
I mean, I am more than happy to continue, Your Honors, unless you want me to sit down, and I'll do that.
That's up to you, but I think the suggestion is maybe it isn't
okay,
necessary.
well, then I'll sit down. I will sit down. Thank you, Your Honor.
Thank you, counsel. Do you think that even if your client had the same supervisor, that his conduct was the same? It seems to me that in the alleged comparator's case, we had an allegation that he was rude. But in your case, you could actually make an argument that your client just does not understand what child abuse is, which is the very thing he's there to protect.
Well, Your Honor, I'm very glad you brought up that point, because that could go to the crux of this issue as to what constitutes appropriate conduct on the floor. I'm not on the floor of the hotline. I'm not going to stand here and suggest that Mr. Clemmer's particular behavior on that occasion was ideal for a hotline counselor.
Well, we're not talking about ideal. Could you imagine what would happen if you have a man who thinks it's okay to do that and who minimizes the complaint of a concerned parent, and then it turns out that the step-parent he's complaining about does some things that are far worse, and now we find out that DCF has done nothing about it? I mean, people would be awfully upset with DCF for not protecting a child.
And that's a legitimate statement, Your Honor, but I think the court should also consider this. Part of the training, putting it in context, part of the training that the people who do this is a tough job. And part of the training that they get, and I'm sure as some on the court have done family law, understand that this hotline issue with the DCF a lot of times is used as a sword in particularly acrimonious.
Well, sure it is, but it's not that. It wouldn't have been your client's right to decide whether or not it was being used as a sword or a shield.
But
I mean, when you've got a person responding to a complaint about a 5-year-old being molested, and he kind of makes light of it and jokes about whether or not the girl has a chest, that's somebody who's beyond rude. That's somebody who just doesn't get it.
Respectfully, Your Honor, again, I'm not suggesting that that would be the way that I would respond to a call of that nature. But
all of this is totally irrelevant to the case that you brought in this case, which accuses the agency of firing your client because he's 68 years old. Now, that, on this record, that borders on the frivolous, if not more than that.
And I will speak to that, Your Honor. With respect to your point before, part of the training that they receive as hotline counselors, my understanding is that techniques to ferret out when someone's calling to make a, for lack of a better term, bogus complaint. And that was the representation that my client made when he was speaking to what he did. He was sarcastic in his tone on the phone with the person. He was apologetic for it afterwards. But that is a legitimate concern that counselors are trained to address when people call in making fraudulent complaints.
The case is not whether he was properly fired or not, although it's obvious that he was. The case is whether there's any evidence whatever that he was fired because he was old.
Well, we think that the evidence is the fact that the comparators that we've proffered, Your Honor, have engaged in conduct far more, and who are in a younger group, have engaged in conduct far more continuous, ongoing, and egregious than Mr. Clemmer ever engaged in, and have gotten raises, have been allowed to.
There might be a difference between the comparator being rude, but your client just not getting what his job is, not understanding even what his job is.
But I think if you, respectfully, I think if you look at the record, Your Honor, and look at some of the specific instances that are cited with respect to the comparator.
We are not supposed to, and we cannot, and we shouldn't, judge whether this lady was correct or not. The only issue is whether she was motivated by his age, and there's no evidence of that, none.
We do believe that there's evidence, Your Honor, because if you look at the record, you'll see this issue with the independent, separate decision maker. A termination letter was issued before an investigation was conducted. So you can't very well say that.
What is that? It means that they don't like him. Does it have any evidence that they terminate him because of his age?
Well, because of other younger people are allowed to engage in conduct worse and are allowed to keep their jobs. Thank you.
Thank you, counsel.
Thank you.
Thank you, both counsel.